Okay, so good morning. So today we're going to go over transfer of title. And when we discuss transfer of title, after this unit, we will be able to discuss or understand the fundamental concepts of title as it relates to the ownership of land and the processes and instruments used to apply these concepts. We'll talk about testate and what that means, intestate, wills, the probate process, and some of the key terms in this unit like adverse possession, bargain and sale deed, deed of trust, devise, general warranty deed, grantee, grantor, intestate, probate, quit claim deed, special warranty deed, testator, title, transfer tax, and so forth. So when we talk about the transfer of title, what does that mean to you? What does that mean to everybody here in the class? We talk about
the transfer of ownership of the property from one to another.
That's right. Now, generally, who's the person as far as the role in the transaction that handles this sort of thing? Who's the person? Is it the real estate agent most of the time?
A title company, a lawyer.
Right. So, I mean, for the most part, real estate agents, we don't deal with this. But do you have to be a little familiar with it? Does the state of Connecticut want you to kind of understand the general concepts of it? Yes. And so that's the main point. And that's why we do have to use this. Or you go over this principles and this unit. So when we talk about the word title, is there a piece of paper for real property that's called a title? Who knows?
Oh no, what happened?
Anyone? Is there a piece of paper that's called a title? Yes, no, maybe?
Yes.
Okay, so you said anybody else? Yes, no, maybe?
Yes.
Yes? Okay. So here's the point. The point is the answer is no. When it comes to real property, there is no document that's called the title. Now, you might be like, oh, Rob, that's not true. I have the certificate of title for my Escalade. And somebody else says, well, I have the certificate of title for my camper. And the other person says, and I have the certificate of title for my motorcycle. And I have the certificate of title for my big $4,000 printer that I have. Okay, well, that's considered personal property. And yes, for personal property, you do have, in many cases, a certificate of title, but not for real property. You see, when we talk about title for real property, we're really talking about a concept, right? So title for real estate means the right to or ownership of it. It represents the owner's bundle of legal rights. It also serves as some sort of evidence of that ownership. So if you say, well, I hold title to this property, right? That means that you have some sort of ownership of it or possession of it, okay? But there is not a document that says this is your certificate of title. Does that make sense? All right. So we know that real estate can be transferred voluntarily, right? By sale or gift, right? It can also be transferred involuntarily. So what would be an example of, let's say, real estate that's transferred involuntarily?
Would that be like if you lost your house? Would that be like the foreclosure kind of thing or no?
Yeah, that's involuntarily. They foreclosed on you, or somebody passes away, right? Is another one. And so forth. And so there's different ones. But let's start off, because we started off by talking about voluntarily. So let's start off by voluntary. So when we talk about voluntary alienation, right? We're not talking about alien. I know this is 2020. Everybody's freaked out about everything. We're not talking about alien nation, right? We're not talking about a nation of aliens, right? We're talking about when you alienate. I'm supposed to get a little laugh out of that. Nothing. Okay. We're talking about you if you are sick and tired of something, you alienate yourself from it, you separate yourself from it, you put it to the side, right? That's voluntary alienation of property. Like where basically you transfer the title voluntarily, maybe by making a gift to somebody or selling the property and so forth. And so the different definitions in this section that they want you to know is, first off, you're probably going to have a deed that's involved. And what's a deed? Who knows?
So it's a document in which the owner of the real estate conveys the right of title.
That's right. So that's the actual piece of paper, is the deed. Now, where is that deed usually recorded? Where would that deed be recorded?
With the town?
Right? In the town clerk's office here in Connecticut, it would be in the town hall, in the town clerk's office, right? And the person who is transferring the deed or giving the deed, they are called the grantor, right? The grantor. So what would be the name of the person that would be receiving the deed? What would they be called?
Grantee.
The grantee, right? So remember, the grantor conveys the property to a grantee who receives the property. And usually that deed is the document that's being transferred. Make sense to everyone?
Mm-hmm.
Okay. So they want to give you your book to know, you know, the opportunity to know all the different requirements for a valid deed. Okay. And so here's kind of like the general ones. Number one, the grantor has the legal competency to execute the deed, right? They are named with reasonable certainty. There is a statement of consideration. So when we say statement of consideration, what are we talking about? What does that mean? We have a statement of consideration.
They must be of legal sound mind, legal age.
Right. Well, when we use the word consideration, what we're really kind of talking about is something of value, right? It could be for $1, it could be for $1 million, it could be for love and affection, it could be, I mean, there has to be something of value as to the reason why. It could be for a nominal value, but the whole point is statement of consideration is usually required for a deed, and it will tell you, you know, why is it being transferred, okay? And then we have the granting clauses, which are words of conveyance, which we're going to go over. And so you're going to need to learn a little bit more about that. We're going to talk about the habendum clause, basically defines the ownership right received by the grantee. You know, what are the rights of the grantee? The legal description of the property. Even if the property doesn't necessarily have an exact address, it might be like 00 Main Street. Right? It might be lot number 7 of Sunny Valley Acres subdivision, right? But the point is that it has to have some sort of legal description, okay? And then we have any relevant exceptions or reservations about the property that would be on the deed. We have the acknowledgement and notarization of the signature of the who? Who has to sign the deed?
Both grantor and grantee.
Grantor.
Okay. So this is a tricky one, and it took me even a while for me to exactly understand this, you know, 20 years ago. The grantee doesn't sign the deed. Does it have to be delivered to the grantee? Do they have to accept it? Yes, but the grantor is the only one that signs the deed. So please remember that, because that could easily be a question, a type of question, the way that they word it on the state exam. Remember, the notarization and the signature of the grantor has to be on the deed. But does the notarization and the signature of the grantee have to be on the deed? No. Okay, so put that in your mind, because that could save you a couple points on your exam. All right. So the deed should include any limitations, exceptions, reservations, things that are subject to, and so forth. So like we said, the grantor should have, definitely has to be of legal age or lawful age. Usually that's going to be 18 years old in most states, right? Because a deed executed by a minor is usually going to be considered what?
Invalid.
Voidable.
That's right. So the term they want you to know, and it's in italics in your book, is voidable. It will look like a good deed. Everything will look good on the surface, but once it's understood and found out that it's a minor, it's going to be voidable, right? So after reaching legal age, then the minor can choose to treat the deed as a valid conveyance, or have the conveyance recognized of no legal effect by the court. So the grantor also has to be of sound mind and legally competent, right? Because remember, you don't want to be signing contracts and having agreements of some and so forth with someone who maybe you don't know or feel is 100% legally competent, right? The grantor's name has to be spelled correctly, right? That's pretty simple. Now the grantee, it has to have a name of a grantee. And usually it's a specific person, okay? But remember, the grantee doesn't necessarily need to sign anything. We talked about conveyance, right? Has to have a clause on the deed acknowledging that there's some form of what? Consideration. And again, what's consideration?
Something of value.
Something of value. Usually it's stated in dollars. It could be considered, you know, let's say someone's going to give the property to their son or daughter or mother or father. It could be, you know, a nominal sale, nominal consideration, but it has to be something of value. Now, in each deed, right, a deed has to have a granting clause. So we're going to talk, and I know we're getting to this, we're building up upon it. We're going to talk about all these different granting clauses, and we're going to talk about these different types of deeds, and you have to understand, oh, this is a special warranty deed. So here's the granting clause for it. This is a general warranty deed. Here's the granting clause that they would use on that. So you see in your book there's 4 different types of granting clauses that we are going to review. And so you need to know, well, for what kind of deed those granting clauses will apply to, right? Habendum clause basically talks about, okay, what are the owner's special rights? Now we're used to, for the most part, that the owner of the deed or the property has full rights to the property. But what if it was, example, like a timeshare? Okay, so if it's like let's say a timeshare, well, maybe the owner of the property only has 1/52nd ownership, you know, 1 week out of 52. And maybe they only own the 27th week of each year. So as an example, in the habendum clause, that's what it will refer to, right? What type of ownership, what are the owner's rights, as well as how are those rights limited in any way? Make sense? We talked about the legal description, if there's any exceptions or reservations. So when we say exceptions or reservations, what are we talking about? When we use those terms, exceptions or reservations, what are we talking about?
Any encumbrances?
Yep, could be any kinds of encumbrances that are on the property. Could be that there's some restrictions as to how it could be. Like one person was telling me the other day and how they looked into buying this property, but it was a federally funded property. And there were nice houses in a nearby town that is considered to be really pretty nice with good school systems. But if you get approved to buy this property, which you're going to be spending, you know, a couple, $200,000-$300,000 on this, well, in the deed it says you cannot will that property to any of your heirs. It has to be a resale because it's a federally funded property. So, you know, we had a discussion, and we can have a lot of debates on that, But the gentleman and I had a discussion about it, and he was like, and I agreed with him. He was like, listen, there are people, the way I kind of looked at this, he's like, there are people that they're trying to build something for their family. They came from another country, or they started off maybe with what they feel is disadvantages, and they finally built themselves up and their family up, and they want to leave something good for their children, and they're not going to be able to leave that property because of some of the federal guidelines for these properties. All right. And so that was kind of like, wow, that's a huge disadvantage. It doesn't really make sense for people. Right. It doesn't really make sense for people to be able to be bound to those rules. So, but everybody has their own opinions on that. But anyways, that could be an exception or reservation for a property. Signature of the grantor, I think we spoke about, and you probably understand that one. You have the grantor has to deliver a copy of the deed to the grantee. The grantee has to accept it, but they don't have to sign anything, which is pretty wild if you ask me. So delivery and acceptance is important. Okay. Any questions on that so far? All right. Execution of corporate deeds. So what is a corporate deed? Who understands that concept?
That when various businesses have interest in a property.
Right. So can a corporation own a property?
Correct.
Yes. Right. And so there's two basic rules that they want you to know about when a corporation owns a property. Right. Number one, a corporation can convey real estate only by the authority defined in its bylaws or on the basis of a resolution passed by its board of directors. So just remember that if you're dealing with a corporation, whether buying or selling property, usually you have to get a copy or understand, okay, this was approved by someone authorized by the board of directors. Make sense? Okay. And then second of all, is that deed conveying that corporate owned real estate can be signed only by that authorized person. Okay. And I've had some issues before where I'd go to talk to someone about a property and they want to buy it or they want to sell it. And, through the corporation and I, it's kind of can be a little bit of a touchy scenario where the guy was the CFO. And I said, hey, listen, so I understand that, this property is owned by the corporation. You have a resolution or anything authorization. Well, I'm the CFO and I could do what I need to do. And I'm like, listen, it's not like I'm questioning you or your authority. It's just that that's one of the things we need to look at. Can we get a copy of that? And then come to find out two weeks later, we still were under great terms, but it was the accounting manager who had the document in his name that says that he had the rights to sign documents and so forth, not the CFO, right? And, so things can get a little bit tricky when we talk about that sort of thing. All right, any kind of questions on that? So let's talk about the different types of deeds and the most common ones that they want you to know about in this unit. So the first one is a general warranty deed. This one provides the most protection to the buyer because the grantor is legally bound by certain covenants or promises or warranties, right? And so with this, you have these covenants. There's actually 1, 2, 3, 4, 5 covenants, right? And so when we say the word covenant, we're talking about a promise or a warranty, right? And so the first covenant is called the covenant of season. So who knows what's the covenant of season for a general warranty deed? What's the covenant of season for a general warranty deed?
Is that when the grantee is able, if damages are to the property, could get full
Right.
price if the covenant broken between the guarantor?
Well, I mean, basically, it is saying that, yes, you're right. The grantor is making a promise or a warranty that they own the property and they have the right to convey title, to transfer title. Okay, so that's the covenant of season. Now, the next one is the covenant against encumbrances. And so when we talk about that one, we're talking that the grantor warrants that the property is free from liens or encumbrances unless they have already been stated in the deed, right? And if they find out that there is other encumbrances or like, for instance, other types of liens or easements on the property, the grantee can sue to recover those costs. Make sense?
Okay.
We also have the covenant of further assurance that the grantor promises to obtain and deliver any instrument needed to make the title good. And you know, these kind of things, and I know some of you might be getting a little confused type of thing, but these are really the kind of things that, you know, for the most part, the attorneys deal with. And most of the transactions we're doing is usually a general warranty deed or a special warranty deed. And, you know, the grantor has done all kinds of homework and they have title insurance and everything's been taken care of. So it's not really needed to be worried about. But we need to be familiar with these things. Covenant of quiet enjoyment. Basically, the grantor guarantees that the grantee's title will be good against any third party. Covenant of warranty forever. The grantor promises to compensate the grantee for any loss. Okay. Now, when we talk about a general warranty deed, right? So the first question we need to ask is, what is the granting clause for a general warranty deed? What's the granting clause? Right? So they go back to your couple pages before that, and it's the first one. I, whoever the grantor is, they use the example JKL, convey and warrant. So I, JKL, convey and warrant. That's for a general warranty deed. Now the second deed is the special warranty deed, where there's two warranties or guarantees. Number one, that the grantor has received title, and number two, it was not encumbered during the time they held title. So this might be, let's say, for instance, the lender, a bank who owns a property that was foreclosed on previously. They're probably going to give you a special warranty deed because they don't want to make promises for what happened before then, right? They want you to know, hey, listen, during the time when we held title, everything's been fine. No one's made any claims against the property. And if there's any additional issues and so forth, we will cover them for the time that we held the property, right? And so what is the granting clause for a special warranty deed? This is the next one. You have to memorize these because otherwise you're going to have a problem in the long run. So who knows what's the granting clause for a special warranty deed? So usually I go, who read the chapter before the class? Who studied? Anyone?
The grantor remises, releases, alienates, and conveys.
Yep. So there you go, right? The grantor remises, releases, alienates, and conveys. That's a little bit hard to remember, but you have to remember. Okay, so now we learned general warranty deed. The granting clause is convey and warrant. Special warranty deed. The granting clause is remise, release, alienate, and convey. Okay, who has questions on this sort of thing so far? Is it confusing you on a lot of different things, or are you understanding it? All right, so the next one is a bargain and sale deed. Okay, really where there's no warranties at all, there's no promises, but basically it implies that the grantor holds title and possession. And this is where a lot of times it's going to be hard to get title insurance, and attorneys don't want to deal with this sort of thing because they feel like it's putting their client at risk. So years and years ago, here's my quick little story is there was a 2-family for sale. And so we go to make an offer on it. My client wants to make an offer. And we find out that, hey, there's only going to be a bargain and sale deed transferred with the sale of this property. Okay, everybody follow me? So we said, well, what do you mean? How come there's only going to be a bargain and sale deed? And we find out that there were 2 sisters that owned the property. And they supposedly, right, we have to use the quote unquote, supposedly they decided, these 2 sisters, that they were going to go back to the old country and stay there for the rest of their lives. Okay. And so before they left, each sister had a son. And so before they left, each sister supposedly wrote on a piece of paper that they're giving the property to the son. There was nothing recorded in the town records. There was no attorney involved. There was no formalities taken care of. But now supposedly these 2 sons, they want to sell the property. So can you buy that property from them? What do you think? Can you buy the property from them? Yes, no, maybe. You don't want to answer. What do you think? Yes, you can buy the property from them. It's not like against the law, right? However, will it be hard for you to get title insurance? Probably yes. And if it's hard for you to get title insurance, will you be able to get a mortgage or give a mortgage on the property? You probably won't. There's probably not a lender who's going to be like, oh yeah, this is fine. Because you see, you can buy that property and live happily ever after. Or all of a sudden someone can knock on the door and say, hey, what are you doing here? My mother owns this property. You know, maybe it's the sister that we never knew of. Or maybe the 2 elderly sisters come home from the old country and say, hey, we never gave anybody permission to sell our property. And now you find yourself in court and you only have a bargain and sale deed, which means that you knew that there could have been some risks, right? And there's no promises except to say that the grantor does have title and has possession of the property. They don't have anything else. You're not going to be able to call them up and get protection, you know, and say, hey, well, can we talk to your attorney? And are they going to be able to get their title insurance company involved and help us out? There's no promises there. And that's why you probably, when you bought the property from those 2 sons, you got like a pretty good discount. You see, so there are some deals in real estate that are too good to be true. So please be careful. In fact, my client, they still wanted to buy the property. And I told them, I said, listen, why don't we go talk to this attorney that I know before we finalize the documents, because I think it's a little bit risky. So we go and talk to the attorney, which my client knew the attorney. We both knew him pretty well. And he started yelling at him. You know, this is a good like 10 years ago. He's like, you guys, every time you guys come to me, you're trying to put a round peg in a square hole, and it doesn't work like that. And I don't do business with those kinds of people. You're going to get yourselves into trouble just to save a few dollars, and it's not worth it. We were like, okay, sorry. We don't want any problems here. And, you know, basically my client, which is my friend, pretty much realized, okay, I better not buy this property. Does that make sense to everyone? All right. Now, what is the granting clause for a bargain and sale deed? What's the granting clause?
Is that the grants, bargains, and sells?
You got it. So you see, that one's kind of easy to remember. Okay, and just to kind of go back, general warranty deed, the granting clause is convey and warrant. Special warranty deed, the granting clause is revise, release, alienate, and convey. And then bargain and sale deed, the granting clause is bargain and sell. Now, the last one we're going to go over is a quit claim deed. So when we talk about a quit claim deed, what are we talking about? The lease protection of any deed, no covenants, no warranties. Usually when I see people using a quit claim deed, it's to like maybe clear what they call a cloud on the title, like somebody's name is incorrect or they're changing a name, maybe somebody gets married or they're transferring the property to a family member, that type of thing. So it's not always, you know, it's not usually used for like a sale type of thing. Okay, so the next section in your book talks about a deed of trust. Do we use deeds of trust in Connecticut? Pretty much not, no, and I've been told no because of the fact that it doesn't correlate with our foreclosure laws, right? And so when we talk about a deed of trust, that's used in some states, right, where there's three parties. There's a trustor, a trustee, and then a beneficiary, okay? And so when we talk about that, we're talking about, okay, you have the trustor, who's the person that's basically giving the property, gifting it, selling it, whatever it might be, to the trustee. And the trustee is going to hold on to that documentation until the purpose is fulfilled. Maybe a certain amount of money, maybe a certain action that someone has to do. They're going to have a deed of trust. And then when that beneficiary or the buyer pays in full of that property, there's no, everything's been satisfied, whatever needed to be done, then that buyer will get, or beneficiary will get what? A trustee's deed. Okay, so you have the trustor that gives a deed of trust to the trustee to hold on to it. Usually that person might be an attorney or some type of executor or executrix, or maybe could be somebody in the family that they're, you know, hold responsible fiduciary obligation to the trustor. And then when the duties have been fulfilled, you know, like paying off a certain amount of money or completing some action, then the beneficiary or the buyer gets a trustee's deed. Now, let's say that rich grandfather said, hey, I'm the trustor and I am going to give my granddaughter these 100 acres of land if she gets her master's degree by the time she's 25. Okay, and let's just say the granddaughter's mother is going to be the trustee. So he would basically give a deed of trust to the granddaughter to his daughter. And that deed of trust is going to be held by her, so that, okay, now the granddaughter is 24 years old. She graduates, she has her master's degree, and boom, she gets the trustee's deed. Or now it's her 26th birthday. She didn't get her master's degree. So the land goes back to the grandfather, and the trustee sends a reconveyance deed with that land back to the rich grandfather. So does that make sense to everybody? Kind of little example there. What kind of questions do you have on that?
When did the grandfather die? Who does it go to if it's not met? Is that something that?
There's usually going to be clauses in there to say, okay, is it going to go? And that might be the reason why they do a deed of trust, because maybe the grandfather feels, well, what happens if I pass away before she turns 25? That's why we need a trustee to handle everything. And there's going to be a lot of different stipulations. You know the way attorneys can be. They're going to, hopefully, if you have a good attorney, they're going to try to consider every certain circumstance. Hopefully. We could also have a deed pursuant to a court order. So that, you know, some examples, they call them master's deeds, executors or administrators deeds, sheriff deeds. You know, these are basically where the property is transferred by will or by court order, and the probate court might be involved and so forth. So that might be, you know, deed pursuant to a court order. So sometimes we're selling a property where we have to get the probate court approval. You know, we get an offer for $225,000, and we have to show them why, you know, all the marketing we did and why it's worth it to sign that purchase and sale. Okay, and so sometimes you have a deed like that. We also have in some states called transfer tax stamps. Who knows what those are? Transfer tax stamps. Anyone know? Does it cost you money to sell your property?
Yes.
Does the government want a piece? Yes. So
Yes.
other states, it's usually determined by the purchase agreement who's going to pay, right? It could be just the seller is going to pay the transfer tax stamp, the transfer tax. It could be just the buyer's going to pay, or they could be splitting it 50-50. It's going to depend on the agreement. But when in Connecticut, we have what's called a conveyance tax. And this conveyance tax is usually, I mean, I've never seen it any other way. It's paid by the seller. And that conveyance tax is made up of a state tax and a municipality or a town tax, right? And so usually that has to be paid upon transfer of the property, right? And so there's different ways of calculating it. Usually what you're going to want to do, you're going to want to figure out, okay, well, how many taxable units do we have here? So what does that mean? So we're not going to do the math today. We're actually going to do it on Tuesday morning, right? We're going to do more transfer tax calculation, and we're going to do conveyance tax calculations, and we'll work on the math on Tuesday. But the basics of it is that you take the dollar amount of the purchase price. So they give you the example that the house sold for $300,000. Okay. And they say, okay, it has a transfer tax of $1.50 for each $500 of sold property, right? So how many taxable units would there be? Okay, so let's do a little something. I don't want to get too deep into it, but I do want you to understand the basics of it. So let's do a little screen sharing, right? So we said, let me clear this. We said that the property selling for $300,000. And we said that the transfer tax in this particular state, because it's different for everything, right, has a transfer tax of $1.50 for each $500 or fraction thereof, for each $500 of a sale. Everyone with me so far? Right? So our next step is to figure out, well, how many taxable units are there? So how would we figure that out, right? So step number one.
Well, you would divide 500 into the 300.
That's right. So it would be 300,000. Oops, something's going on here. I don't know. It feels like the Zoom is a little bit slow here all of a sudden. Has that been happening? Do you guys see that?
Yeah.
Getting a little wonky on me, right? So I don't want to get too crazy here because it's kind of messing me up. Maybe I can do this. Let's try this, see if it makes it easier. All right. So I'm going to do what? 300,000 divided by
500.
You got it. And that's going to equal what?
600.
600 taxable units, right? And then the second step, so this was technically, this was step one, right? 600 taxable units. That's what we had to figure out. So the next step, step 2, is going to actually figure out, well, how much is the actual tax? So what are we going to do? We're going to say, okay, there's 600 taxable units, right? Multiply times what?
The $1.50.
$1.50, which would equal what? $900 to the state. So does that make sense to everyone? Right? And so usually, okay, there's going to have to be a transfer declaration form or transfer statement or affidavit of real property value that's basically going to be signed by both parties, the buyer and the seller. And the attorney is going to, the attorneys are going to be the one to do that. They're going to put, okay, what's the full price of the property? What's its legal description? The type of the improvement, and so forth on the deed, so that they can then have that calculated and they can now actually record that. Right now, and they do that, you know, some states, I guess they would, or towns, they would put like a stamp on that. Okay, there are certain properties that are exempted from that. Who knows what kind of properties or deeds would be exempted from like a transfer tax?
Like churches or schools?
Yep, it could be like charitable, religious, educational nonprofits. It could be gifts of people. It could be conveyance between 2 different governmental bodies, like from one town to another, or from the state to a town. Partitions. So who was here for unit, I think it was unit 4, when we talked about partitions. Who remember what's a partition? Anyone remember what's a partition? Come on, I know you can remember this.
To terminate out of a co-ownership?
Right? So if you had like what was it, the joint tenancy, right? And then somebody, there were 3 owners and someone wanted to get out of it and they couldn't come to an agreement. So maybe it went to court and the judge actually says, okay, well, what we will do is we will partition the property, and they'll either force a sale of the property or division of the property. So that could be an example there as well, where that, you know, it would not be, it would be exempt. Let's say it would be exempt from the conveyance tax. Does that make sense to everyone?
Mm-hmm.
All right. Anybody have any questions on that? All right. So that's really everything when we talk about voluntary alienation. So does anyone have questions about voluntary alienation? Anything that you wanted to go over or talk more about? All right. So the next one is involuntary alienation. Okay. So when we talk about involuntary alienation, we're mainly talking about properties that are without the owner's consent, right? Involuntary without the owner's consent, right? Could be condemnation, foreclosure, maybe a person has to satisfy a delinquent tax or a mortgage lien, right? Could be when a person dies intestate. So when a person dies intestate, what does that mean?
They don't have a will.
Right? They don't have a will. They did not have a valid will, right? And then if somebody passes away and they don't have a valid will, they'll look for heirs and the probate courts will get involved, right? Now let's just say they can't find any heirs. So they can't find anybody that you know, would be an heir to the property. What happens then?
Wouldn't it go to the state?
It would go to the state. Okay, after how many years would it go to the state in Connecticut?
Isn't it 7?
Well, it sounds like that could be a pretty good number, but it's not 7. What is it? Anyone else? No?
Isn't it higher, like 15 or 20?
Right? So it's actually 20 years. So in the state of Connecticut, it would be 20 years in which you would basically, the property would then go to the state. Does that make sense for everyone? Anyone have any questions on that? All right. So let's talk a little bit more about that. I'm trying to get to one particular section here. All right. Let's see here. Where am I? I like to use a little chart here. So the little chart is this one. All right. So here we go. So can you see that transfer of title? Okay. So we talked a little bit about intestate. So let's talk about what else by operation of law. The first one that they talk about here is condemnation. Okay. So a person owns a particular property that they want to put a highway through, right? Condemnation allowed by state's power of eminent domain. So they want to put a highway through this particular property, and what they find, now they have to do what they like to call what? Eminent domain, government body or designated authority to be able to take public property for the use of, or be able to take private property for the use of you know, they say for public use, for the best welfare of the public, okay? And so that person is going to be offered what they believe, let's say the state, what the state believes is a market value. And now, you know, I know somebody that works in the state of Connecticut, and they said, hey, listen, you know, we'll try to give them a pretty good price, but we're only going to be able to offer so much. And then sooner or later, they're going to tell them, hey, listen, we're going to give you this amount of money. And in 9 months, you have to move by 9 months. Because after 9 months, the property is going to be condemned. And it doesn't mean that it's a crummy property. It could be a beautiful home, but if they want to put a highway through there, they're going to say condemnation. They're going to say condemned because the town or the state is taking away, right, the certificate. They're going to take away the certificate of occupancy. So the property will be condemned. So does that make sense to everyone? The next one is a foreclosure. So if a property was foreclosed on, that's involuntary alienation, right? And then the property is taken by the creditor. Or if the person doesn't pay their taxes, the property can be taken for a tax sale to be sold to somebody else. Or like we talked about, transferred on the death of the owner in Connecticut, it's 20 years that the property will go to the state by the term escheat. Okay, it will go to the state by the term of escheat. Now, the next one, or the last one that they want you to know about, is adverse possession. So what is adverse possession? Well, adverse possession is basically the open, notorious, continuous, hostile, adverse use of another's property for a prescribed period. So they're going to say, okay, in the state of Connecticut, who knows how many years you have to show that you've been using this property before you can make a claim for it. So this is a number you have to memorize too for the state of Connecticut. Anyone know?
20 years.
All right, well, at least you're guessing, so I guess that's all right, right? So the answer though is 15 years. So remember, in Connecticut, it's 15 years. Okay, and it has to be open, meaning that it's obvious to anyone. You're not hiding. It's notorious. It's continuous. Now, one of the things that comes along with that is the term called tacking. So does anybody know what tacking means? So let's say you bought this property from your father, and you've always been, here's the property, and here's the neighbor's property, and you've always been like going across here. Your father was, when he owned the property, using this person's property. Okay. Now maybe you got the property, but you only owned it for 3 years. But your father can prove that he's been doing it for more than 12 years to equal the 3 plus the 12 equals the 15, right? So you can do the process or use the term called tacking, which is using other or the previous owner's time that they were using that property. Does that make sense to everyone? And it has to be hostile without the true owner's consent and against their owner's right of possession. And then you can make a claim against the property. Now, remember, you have to do that by court. And the only way for the current owner to stop the 15-year clock, how do you stop it? So if you own property, is it enough for you to go outside and yell and scream at the people, get off of stop using my land? Does that stop the 15-year clock? Anyone?
No. No.
How about if you have your attorney send them a letter? Does that stop the 15-year clock? No. How about if you call the police? Does that stop it? No. You have to bring them
Go to court.
That's right, a court injunction. Okay. Does that make sense to everyone? All right. So again, we are talking about the wonderful world of conveyance to property, and we have to talk about conveyance of a decedent's property. Okay. So somebody has passed away. Now, if they pass away testate, that means that they have a will, right? If they die intestate, that means they don't have a will. And how is it going to be decided how things get distributed? Through probate, right? And there's going to be, each state, including Connecticut, has the statute of descent and distribution, right? And so even in your book, they give you some examples of how a person will pass away. What's the sample statutory distributions? Like if you're married, if you're not married, if you're unmarried with children, if you're married with children, and so forth. Okay. And so that's going to break up the transfer of title by descent. Now, so remember, probate is important for you to understand the basics of it. Okay. There's also the way that wills can be written will decide whether they're allowable or not. So example, does Connecticut accept non-cupative wills? Non-cupative. Who knows what's a non-cupative will?
Could it be one that, just taking a guess, that somebody kind of wrote on their own at their house, not drafted by a lawyer or notarized?
Well, it's an oral will. And in Connecticut, is that okay?
No.
All right. How about a holographic will? So you see, these are terms that are in your book in italics, and so you need to know it. What's a holographic will?
Handwritten.
Handwritten. And in Connecticut, is that acceptable?
Yes.
No.
No.
How about even a video will? Will they accept will by video? No, because you don't know who's behind the camera. They could be like, oh, you better say this. They're holding the camera and then they're holding a gun in this hand right here, right? Maybe that's the Italian side of me talking. I don't know. Maybe I shouldn't have even just said that. But the whole point is that they won't accept video wills either. All right. So that is mainly this unit that we needed to go over. I'd like to get started on the quiz, but before we do so, who has questions?
So quick question back to what we were just talking about. So the only will, so what will they accept? It's written, but it has to be notarized, right?
That's right. That's why you usually want to go to an attorney and have it done the right way and have it notarized and have it recorded the right way. I mean, I don't know every little step that they need to go through, but if you go to an attorney and do a will, you're most likely not going to have any problems. But if you think you're going to do an oral will or a handwritten will or a video will, there could be a lot of issues that come up with that. And it could be, you know, that could be tested in court and probably not used as valid. What other kind of questions?
I have a question. I don't know if there's a difference because this was in Florida, but I was told by a realtor out there that if you're a single owner of a home and you don't have anyone else on the title of the house, however, in a will, you write that if something were to happen to you, the house will go to this person. But she told me that in a case like that, the bank can still fight for the house and it doesn't guarantee that that person will get the home. So
Well,
the only way, that's what she told me.
Well, you got to think about the variables of it, and there's a lot of different ways this could go down. If there's a mortgage, if there's money owed on the property, right?
Yeah,
the
with the
bank
mortgage.
is going to be expecting to get that money, right? So, you know, if that person is able to pay that money to the, you know, the remainder, maybe the house is worth $200,000, someone passes away, they still owe $40,000 on the house. They want to give the house to their daughter. That the bank is still going to expect to get that $40,000, or they're going to want that house to be sold to get that $40,000. They're not.
They'll want money up front.
What's that?
They'll want it all up front or no?
Well, I mean, if it's sitting in probate court for a little bit while it's being sold, that's okay. Or maybe while it's through probate court, maybe the daughter is trying to do some sort of loan, you know, and it takes 30, 60 days, that will probably be okay. But they're probably not going to allow the property to go into the daughter's name and then she just continue to pay that monthly payment, because the bank didn't sign up to get payments from the daughter, and they don't necessarily have the credentials of the daughter, and so they're going to be expecting to get that money most of the time. There's a lot of different things that can happen, and probably depends a lot in different states and the lender and the way the probate court works. But just remember, they're not going to just say, oh yeah, don't worry about that 40 grand or give it to us, you know, over the next 5 years. No, they're going to expect it before that property gets transferred past the probate court. Most of the time they're going to want that money.
And if they weren't able to afford to pay that money, the bank can essentially keep the house with all the equity?
No,
Yeah.
so then usually what happens is the probate court will force the sale of it and then pay off all the different lien holders. So they might put it up for auction, or they might have a real estate agent that they'll use, depending on the scenario.
Gotcha.
Pretty interesting though. There's a lot of stuff involved, right?
Yeah, she literally told me that, like, and she saw where, like, if there was a single person and they owned the house and they didn't have anyone on the title, she had a situation where the bank got the house with all the equity, even though she had a will. But maybe the will wasn't legalized in the state of Florida. Like maybe it was just handwritten with no notary or something along that line.
Yeah. And usually it's going to be that probate court. You know, they're going to try to abide by the will if someone left one. But even if that will like broke state laws or that sort of thing, there's just certain things that they're going to, you know, they have their process, which is the way that they do things. And, you know, usually it's like understanding what all the assets are of the person, and then understanding what all the liens and the expenses and so forth of that person, and distribute everything accordingly. So, you know, things can get pretty tricky and so forth, but they do it every day. So they know the way that it's really supposed to be done, and how things are, you know, everything's supposed to be distributed. And sometimes I've seen probate courts go like 2-3 years. It just depends on the scenario. You know, I have this woman, she wants to sell this piece of land, and we've had multiple buyers, but she cannot get this whole probate thing kind of cleared up. I guess she made some mistakes about it in the beginning. I tried to get her in touch with an attorney, 2 or 3 attorneys, and they basically all want money up front. You know, they want a retainer fee, which you have to understand, they don't want to work for nothing either. And come to find is that, you know, the property is only worth like $10,000, this land. And she doesn't really know what to do. She's kind of stuck. So there's a lot of different things that can happen. Who else has any questions about this unit before we get started on the quiz? All right. Well, let's just give it one quick moment and we will get started. So you might want to get out a piece of paper and a pencil. All right. So here is the questions for transfer of title. So number 1, the grantor is conveying an interest that is less than fee simple absolute. This explanation is the extent of ownership will be found in the what? Season clause, granting clause, habendum clause, or exceptions and reservation. Who knows?
Addendum clause?
You got it. It's a habendum clause. Good job. So remember, that's the whole thing about, okay, well, what is the amount of interest that they have in the property? Number 2, a woman conveys property to a buyer by a written document that contains 5 covenants protecting the buyer's title. What is the woman's role in this transaction? So she's
Grantor.
You got it. Number 2 is grantor. Number 3, the verification that the grantor's signature is both genuine and voluntary is what?
An acknowledgement.
You got it. 3 is D as in dog. Number 4, which of these is an example of involuntary alienation? Involuntary.
See?
You know, because sale is voluntary. Gifting it is voluntary, right? And basically, when it comes to involuntary alienation, we're talking about C. That's cheap. And in Connecticut, how many years?
20, 15.
20 years. It will go to the state in 20 years. All right. Number 5, the transfer of any interest in a parcel of real estate is typically in a document called the what?
Deed.
You know it. Remember, it's a deed when it comes to real estate, the document. Number 6, all of these are necessary to a valid deed except.
C.
All right. So remember, you did a great job if you answered that correctly. Does the grantee have to sign it?
No.
All right. Number 7. I do hereby convey to my nearest relative all my interest in the property called 123 Main Street, Bismarck, North Dakota, to have and to hold in consideration of receipt of the amount of $10 and other good and valuable consideration. So when signed, this document is what?
A.
So what are we missing here?
D.
You got
A
it.
name?
It is D. That's right, because we are missing the name of the person, right? It's too
Yeah.
right. It's too vague. The grantee has to be identified. So 7 is D as in dog. Now remember, I'm going to download this on smartsreadvice.com, so you'll be able to go through it again if you want. Number 8, the type of deed that imposes the least liability on a grantor. Least liability on a grantor is a what?
Quick claim.
That's right. That's the least liability out of all the deeds. Okay. Number 9, title is not considered transferred until the deed is what?
Signed by grantor.
But then what else does have to be done after that?
Delivered.
Delivered.
Oh, delivered and accepted.
Even though they don't have to sign it, it has to be delivered to them and accepted. Number 10, Which of these is a guarantee that the grantor has the right to convey the property? That's why you have to know these different covenants. So this one, it's a covenant of season, right? That they have the right to
Season,
convey the property. All right. Number 11, a bargain and sale deed contains how many express warranties?
5.
Remember, we're talking about bargain and sale.
Oh, bargain and sell.
0.
2. Oh,
Well, remember,
Yeah.
with bargain and sale, they say that there is an implication that the grantor holds title and possession, but there's no express warranties. Okay, and that's the story about the 2 women that left for the old country. There's no warranties or promises being made. There's just an implied, 2 implied ones. All right, number 12. Which type of deed is used by a grantor whose interest in the real estate may be unknown? Anybody know? Interest in the real estate may be unknown. Well, there we go. Number 12D is quitclaim deed, right?
it's another quick.
Basically, when it comes down to that, if there's no interest, the grantee will acquire nothing and have no right of warranty against the grantor. All right. Number 13. And we're just going to go up to, we're going to do the first 15. Under state law, 1/2 of the intestate decedent's property goes to the decedent's spouse. 1/4 is divided equally among the decedent's children, and 1/4 goes to the state. If there is no spouse, the children divide 3/4 equally. A citizen of this state dies intestate, survived by an ex-spouse and 7 adult children. If the estate is $865,550, how much will each child receive under state law? So remember, they said that it gets divided.
3 ways.
The children get 3/4 and the state gets 1/4, right? So how would we do that? We do 865. Oh my gosh, now we're having the issues. Let's try this again. We're going to do 865, 550 divided by 4. Right? Can everybody do that on their calculator?
216,000.
Right? So that's
387.
So that's going to go 1/4. That's going to go to the state, right? So the $216,387.50 goes to the state. Are you with me on that? 865,550 divided by 4. That 1/4 goes to the state, and then the remainder amount is divided 7 ways because of the 7 children. And that's why the answer is C. That's how much the children are going to get. Because the remainder amount would be 649. Let me see if it'll work now. 649. I don't know, it's up and down. 162.5. Everybody know how we got that? Or no? Let me just tell you. So let's see, it seems like it's working. 865, 550 divided by 4 equals what? 216,387.50. So we take that, and then we also end up subtracting that to get the 649, 162, and divide that by 7. Does everyone understand that one? Okay, we got 2 more to do. Who has questions on that? All right.
So those are the calculations we're going to do on Tuesday. Some more of those kind of calculations.
You got it. right?
Okay.
But that's one of the basic ones. So you should kind of understand it, right? Because it says right here, 1/4 goes to the state. So there's the 1/4 that's going to go to the state. And if
Mhm.
there's no spouse, because you see, does an ex-spouse count? No.
Yeah.
So if there's no spouse, the children divide the 3/4 equally. So here's the 3/4, right? The 649, 162. Here's the 3/4, and you divide that by 7. All right, number 14. In one state, transfer tax is $1.20 for each $300 or fraction of. If it's sold for $250,000, what will be the amount of transfer tax? So what do? We do 250,000,
50,000.
right? And then what do? Divide it by,
300.
you got it, divided by 300, which equals what?
833.
You got it, 833.33. And then we take the 833, or we just round it up because it says fraction of. So we do 834 times what?
120.
You got it, which equals the wonderful world of what? C is in Charlie. Make sense? All right, we'll do one more and we'll wrap it up for the day. Number 15, in front of witnesses, a woman says to a man, I never made a will, but I want you to have my property when I die. If the man becomes the owner of the property, it is because the state recognizes what kind of will?
None.
C.
C, right?
No,
Because that's a what?
Oral.
That's right. It's a oral will. Holographic is what kind?
Handwritten.
But
Handwritten.
notarized.
Handwritten, if I know how to spell it. All right.
So
And-
quick question. You said all these quizzes that we do, it's on the what? The smartreadvice.com?
Yep. So let me just remind you. Here we are. We're going to go over here. So just give me 24 hours. Okay. And what you should be doing, periodically, you can go here and it will have, if you go here, HTTP smart RE, like real estate advice.com. And so that's basically our YouTube channel, our YouTube page. And you can go under the different playlists like real estate pre-licensing or real estate education. And these will be there so that you can watch them again and you can be able to do the quizzes together again. And you can feel like we are always together here with you working on these real estate questions. Isn't that fun? Right.
Another question. Does anybody know what tomorrow class unit is?
Hold on one
I
second.
wasn't last night.
We'll go over that in 1 second.